Chapter 3 of Tractate Sanhedrin begins discussing the laws of court-administered monetary litigation and testimony. The first Mishnah says, monetary cases are judged before a court of three. Rabbi Meir says each litigant picks one, and they both agree on a third. The sages say that other two judges agree on a third. Rabbi Meir says the litigants can just disqualify the other litigant's judge if they want. The sages say they need a valid reason that he's ineligible. They cannot be disqualified if they're certified experts. Rabbi Meir says each litigant can disqualify the other's witnesses, and the sages say they can bring proofs they're ineligible, but if they're eligible, they cannot be disqualified. The Gemara explains, when it says they select courts, they can both recommend a court, and if they don't agree with the others, they have to find the court they agree on. This applies to a creditor. A debtor cannot reject a court. He can be forced to use the one in his hometown. Others reinterpret this and say that each agree on a single judge and then agree on the third. It debates if the dispute as to who appoints the third judge is based on if the judges need to consent to him. Related, it said that witnesses don't sign on a document unless they know who's signing with them, and this is discussed further. In regards to the permissibility of rejecting the other's witnesses, some say this means that the litigant and a witness reject the witnesses based on a disqualifying flaw of blemished lineage. Others say the dispute is where the litigant says he has two sets of witnesses. It's debated if he needs to substantiate the claim and bring out the second set. He wouldn't be able to disqualify just a single set of witnesses. This is discussed. Others say the dispute is where the witnesses were confirmed to be ineligible, and if this means that the judges can therefore also be disqualified. And this is debated, and it brings many verses and points admiring the people of Israel and criticizing the people of Babylonia and their studies, which largely created many inconclusive rulings, like this entire text, the Babylonian Gemara. New Mishnah. If a litigant says he accepts the other's father to act as a judge, or three cattle herders to act as a judge, Rabbi Meir says he can retract this. The sages say he cannot. If a litigant needs to take a court-imposed oath, and the other said he could just take a personal oath, Rabbi Meir says he could retract this, and the sages say he cannot. The Gemara explains that the father would be acting as one of the judges in this case. It's debated whether it's the plaintiff or the defendant that can potentially retract this. These principles are debated further. It's said that the dispute involves retraction after the verdict is made, and we follow the opinion of the sages that retraction is not allowed. New Mishnah. A list of people ineligible to be judges or witnesses: somebody who gambles, somebody who lends with interest, pigeon flyers, and sellers of sabbatical year produce. Gamblers are allowed if they have another job besides for the fact that they gamble. The Gemara explains the issues with gambling. Essentially, that it's a legal agreement where the party doesn't fully consent to giving up his money as he expected to win, so the collection of the money is technically a form of stealing. It's debated if a wager falls into this category. In addition to not lending on interest, it says that if there's somebody who borrows on interest, they would also be disqualified from testimony. It relates in particular incident. There was a time a butcher was found to be giving non-kosher meat, so he was disqualified from testimony, and it was said he could repent by moving to a place where nobody recognized him, and returning an object of large value, or by throwing out his own non-kosher meat that's worth a large sum. It also defines pigeon flyers. Some say it means betting on pigeon racing. Others say it means using pigeons to lure and steal others, and this is debated further. Some add to the list of people disqualified from testimony: robbers who take objects retrieved from mentally incompetent people, which wasn't initially mentioned as it's uncommon or as it's not technically real theft. Also included is somebody who makes a purchase without the permission of the owner, and also herders and tax collectors and others. These are all qualified. The points on produce collection and sales during the sabbatical year are discussed, along with the verses regarding Sanhedrin's siege against Chizkiah in Jerusalem, expounding on the meaning behind many verses. These are discussed further, and it rules that gamblers are only forbidden to be witnesses if that's their only profession. Some say all these listed disqualified individuals must have their disqualification proclaimed in court. Others say it's everybody besides for a herder. Some say if somebody publicly receives charity from individuals who worship idols, he cannot be a witness. They also say somebody suspected of forbidden relations can give testimony, but is disqualified to testify on the marital status of a woman, or possibly to testify to release a woman from marriage. It's also said that a sharecropper who takes an extra small amount and from not fully grown produce is not legally regarded as a thief and disqualified from testimony. It's debated if digging a grave on the first day of a holiday disqualifies somebody from giving testimony. It's also debated and held that somebody who testified and was then retroactively found to be disqualified from testimony, his testimony is retroactively disqualified. It cites other similar such disputes, and these are discussed further. New Mishnah. The relatives that are forbidden to testify for somebody are somebody's brother, father, or mother's brother, sister's husband, father's sister's husband, mother's sister's husband, mother's husband, father-in-law, wife's sister's husband, along with their sons and son-in-laws. Other add the stepson, but not the stepson's own son or son-in-law. Some said it goes by people who inherit from him. Some say If he was related to the person and becomes unrelated prior to witnessing or testimony, they can testify. Others say if somebody's daughter passed, but his son-in-law has children from her, he's his relative. One's close friend, a groomsman, and one's enemy, somebody he didn't speak to for 3 days due to a fight, are not allowed to testify on him. Others say the Jewish people are not suspected to bear false witness to their friends or enemies. The Gemara gives scriptural source for these points. It gives sources for many of the particularly forbidden relatives. It said a father's brother cannot testify on somebody, including his son and son-in-law, both ways. It debates this, as this is a third-level relative testifying against a first-level relative. It argues on this in sites of sources. Specifically, a mother's husband's son refers to a brother's brother, being a stepbrother. Some say a person can testify about his wife during the first stage of marriage, but only to take money from her, not to obtain for her. This is rejected based on sources. The remaining points are qualified, and it debates who we hold like. In regards to the friend or a groomsman, some say he cannot testify all 7 days of celebration after the wedding. Others say from the first day. It gives sources for the points on an enemy. New Mishnah. A witness is examined by bringing them into a courtroom where they're intimidated so that way they won't falsely testify. Everybody is sent out besides for the most prominent witness, and they question him, and he must specify exactly what happened. Then the second witness is brought in, and they see if his testimony corresponds. The judges then deliberate, and the ruling goes by majority, 2 out of 3. If 2 judges are split and the other judge cannot decide, they add judges. After they do decide, the litigants are brought in, and they announce if the person is guilty or not. Based on a verse, we know the individual judges should not say what they had personally ruled. The Gemara explains, the witnesses are intimidated by citing verses on the importance of being an honest witness. The points on the witness's testimony are qualified, and it discusses the verses on Adam and Eve and the tree of knowledge, and how it shows the importance of never adding to God's words. As Adam said to not eat or touch from the tree, so when the serpent convinced Eve to just touch of the tree, which itself wasn't problematic, she then ate of it too. It cites particular incidents showing the requirement that witnesses be designated where hidden witnesses were not permitted and similar. It also discusses times when witnesses can record an admission and whether an act of acquisition was required. Some say the judges are required to write on the verdict that it wasn't unanimous. Others disagree. The dispute is based on whether the prohibition against saying gossip or against lying would apply here. It's a rule that they just write that the court was split, but they don't specify by which judges. The remaining steps are additionally qualified. It debates the particular opinions based on particular incidents, along with what constitutes a problematic discrepancy between testimonies. It said that discrepancies regarding supplementary details by monetary law, like them saying the loan was comprised of old or new coins, is an example of this. It is debated if such a discrepancy would invalidate a case of capital punishment. Others debate these statements, and it cites a few particular incidents of these laws. New Mishnah. After a verdict is issued, if a litigant brings further evidence, the verdict can then be nullified. If the court gave him a deadline to produce evidence, he must produce the evidence within that time frame. Others disagree and say it can still be presented after. It's also debated if during the trial, the litigant says he has no witnesses or evidence and only finds them afterwards, whether this is valid or not. It is agreed that during the trial, where he said he has no witnesses or evidence, it's invalid if he tries to bring out evidence right before he's found guilty. The Gemara says we follow the opinion that the evidence can be brought after the court's time limit. It said we follow the opinion that additional evidence cannot be brought after the trial ends if he said he had none. It cites an incident where this was accepted, as the case was with a child who was not knowledgeable about the existence of the witnesses. It mentions some related incidents. There are further points. It's ruled that we can force the case to be at the place of assembly if it's the debtor saying he wants to have the case there, and it brings an incident of this. And that's the end of chapter 3.